Yeah, I never been up there before. It's a wild
Okay, welcome, and thank you all for coming today. I'd also like to specifically thank the Utah Headliners chapter of the Society of Professional Journalists and the Utah Bar Association for co-sponsoring this event. I'd also like to specifically thank Michelle Oldroyd and her team. Would you raise your hand? Michelle works tirelessly to put on these events, her and her staff, and we're very appreciative. In fact, Michelle was the one who asked me to moderate today this remarkable panel, for which I'm very grateful. So, my name is Mike Anderson. I'm an attorney at Harvard, McGee & Loveless. I'm a litigator, but I also do a fair amount of First Amendment, media, and entertainment work. Perhaps of particular relevance to this panel, I am the co-chair of the Bench Media Subcommittee, and I'm also one of the attorneys at our firm, along with Jeff Hunt and David Ryman and other colleagues who staff the Utah Freedom of Information Hotline, which some of you may have used in the past. We've taken literally thousands upon thousands of calls. We've assisted dozens upon dozens of news organizations. We've provided training seminars to both news organizations and the government. And all told, we've contributed millions of dollars in attorneys' fees to assisting the public in getting access to information and other freedom of information issues. All of this has been done pro bono, and we just recently celebrated our 25th anniversary, so I'm very proud of that and proud of my colleagues for supporting that. So despite my best efforts to convince Michelle that this should be a panel about Game of Thrones, we're still going to be talking about courtrooms, newsrooms, and the First Amendment. And it is my incredible privilege to introduce our distinguished panelists. Immediately to my left is Judge Jill Pullman. She was appointed to the Utah Court of Appeals in May 2016 by Governor Gary Herbert. Judge Pullman graduated magna cum laude from the University of Utah in 1993 and received her Juris Doctorate from the S.J. Quinney College of Law at the University of Utah in 1996, where she served on the Utah Law Review and graduated Order of the Court. After law school, she clerked for the Honorable David K. Winder at the United States District Court for the District of Utah. Prior to her appointment, Judge Pullman was a partner at the law firm of Stoll Reeves LLP in Salt Lake City. She practiced there for 19 years, during which she maintained a complex civil litigation practice, including administrative, trial, and appellate work. She was a member of the Utah Supreme Court's Ethics and Discipline Committee, during which time she acted as panel chair. She also served on the Utah Supreme Court's Diversion Committee. Judge Pullman currently sits on the Utah Supreme Court's Advisory Committee on the Rules of Appellate Procedure and the Judicial Council's Committee on Judicial Outreach. She is also a member of the Utah State Bar Litigation Section Executive Committee. Would you all please help me welcome Judge Pullman. To Judge Pullman's left is Judge James Blanch. He was appointed to the 3rd District Court in August 2012 by Governor Gary Herbert. He served Salt Lake, Summit, and Tooele counties. Judge Blanch received a bachelor's degree with high distinction from the University of Virginia in 1990, graduating Phi Beta Kappa. He graduated cum laude with a Juris Doctorate degree from Harvard Law School in 1993. From 1993 until his appointment to the bench, Judge Blanch practiced law at the Salt Lake City firm of Parsons, Bailey, and Latimer, maintaining a broad civil litigation practice, including both trial and appellate work. He has worked as an adjunct associate professor at the University of Utah's S.J. Quinney College of Law, and is a past president of both the Salt Lake County Bar Association and the David K. Watkis Sutherland II American Inn of Court. Judge Blanch has been a member of the Utah Supreme Court Advisory Committee on the Rules of Civil Procedure since 1999 and is one of the initial members of the Utah Pro Bono Commission. Thank you for joining us, James. To Judge Blanch's left is Judge Anna Anderson. She was appointed to the South Salt Lake City Justice Court in January 2017. Judge Anderson received her undergraduate degree in sociology at the University of Illinois in 2000 and a Juris Doctorate from the University of Notre Dame in 2003. Judge Anderson began her legal career as a prosecutor at the Tazewell County State's Attorney's Office in Central Illinois, during which time she also received an appointment as a Special Assistant United States Attorney in Peoria, Illinois, to assist in the prosecution of several federal cases that originated in her county. Judge Anderson moved to Joliet, Illinois in 2007, which I looked up the pronunciation, by the way. And apparently there's a big debate over which way, but it's Joliet.
You guys have pronounced the first one wrong. It's Tazewell, not Tazewell.
Apologies.
That's okay.
She moved to Joliet, Illinois in 2007, where she began work as a felony prosecutor with the Will County State's Attorney's Office. She prosecuted cases in that office for 7 years before relocating to Utah in 2012, where she had been employed as a prosecuting attorney in the Salt Lake County District Attorney's Office prior to her appointment. Thank you for joining us as well. And last but certainly not least, Judge Jeffrey J. Noland was appointed to the 2nd District Juvenile Court by Governor Gary Herbert in July 2010. He serves Davis, Morgan, and Weaver counties. Judge Noland has a law degree from the University of Utah College of Law. Prior to his appointment to the bench, Judge Noland served as a managing attorney for the Salt Lake office of the Guardian ad litem. Before joining the Guardian ad litem in 2006, Judge Noland worked in private practice. Thank you, Judge Noland, for joining us. Now, before we dive into the substance of our panel today, if you'd all indulge me for just a minute, could we take a quick poll by a show of hands? How many attorneys do we have in the audience here? Thank you. And how about members of the media? Great. Fantastic. Anybody else from anywhere they'd like to? Okay, great. How many of you would prefer if I just talk about Game of Thrones for an hour? Awesome. Okay, and as we go, if you have any questions, if you please just raise your hand. We have a microphone, and we'll get to your question as soon as our panelists finish their thoughts. So, today we plan to talk about judicial ethics, judicial decision-making, the relationship between the judiciary and the media, and the media's coverage of the judiciary. And we'll sort of take each of those 4 as categories as we go. Now to start, if I could just pose a question to the panel, could you help us understand the difference between, on the one hand, judicial ethics, and on the other hand, judicial decision-making, delineating those two, and also to the extent that they may meet or even overlap?
That sounds like a Court of Appeals question.
Well, all right. So when I think of judicial ethics, I think of the rules that govern how I behave, both in making decisions, but also just in my personal life, in my professional life, the things that I need to be careful of watching out for when I'm interacting with others or engaging in certain activities. And then I think of my judicial decision-making as being kind of just the big part of my job, right? What I do every day is making decisions on the cases that come before me. When it comes to the media and maybe how those two things interact, my biggest goal when I'm thinking of my ethics is to make sure that I'm not engaging in any activities that are improper or that suggest or maybe appear to others to be improper. So, I would never comment, for example, on the cases that appear before me. I would never answer questions to anyone, whether it's the media or friends or family members, about the things that I'm currently considering. I talk to the people on, my colleagues on the bench, my clerks, those are the people I discuss those things with, but that's it. I guess maybe I need a little guidance as to what exactly.
Well, let's take, did you have a thought, Judge Noland?
I was going to say, yeah, I'm kind of along the same lines, is that what I've found is what people really want in juvenile court, whether it's a child welfare matter or delinquency or one of those issues, is people just want to be heard and treated fairly. And so I see that as part of my ethical duty, is to make sure that people, I just find I have to do some hard stuff like terminate parental rights, keep kids in foster care when the parents really wanted to come home, you know, really kind of serious emotional times for people. Had a full day of it yesterday. And ethics is where it's kind of the guide rails where people just want to be treated fairly. And so I kind of think that's how that overlaps into my decision making. Because 90% of the people are happy with my decision as long as they were heard in court and they know I didn't have any preconceived bias or you know, a slant going into it. And number three, that I really did consider their argument and really listen to their side of the case. And like I say, 90% of them, they may not be happy with what I decided, you know, because there's always usually a winner and a loser, kind of that's how court is. But as long as they're heard and really heard, they're okay with it. And that I really thought about it and independently looked at the case. So I think that's where ethics and that decision making kind of come together.
Great. And now let's take the two independently. First, judicial ethics, and then we'll talk about judicial decision making in just a minute. Judge Pullman, you mentioned ethics in interacting with the media, and specifically when you can comment, and maybe, you mentioned when you can't comment. Can we talk about when you could comment, or, I mean, today we're going to be talking about your process and sort of, we're talking in generalities versus about a specific case, but maybe if somebody could help us better understand your personal approaches to the ethics of comment.
Well, everything I say is subject potentially to immediate reversal by Judge Pullman. Judge Nolan he may have the most exposure to issues with the media, given his role as a juvenile court judge. I may be tied for the most as a district court judge, because I do get a lot of requests for media coverage, and I've had cameras in my courtroom a lot. When I was first appointed to the bench in 2012, they were just considering the policies that they have now for allowing cameras into the courtroom, and I was actually asked as part of the judicial selection process what I thought about that, and at the time I said that I didn't have strong feelings, but that I was skeptical about it, and my skepticism was based on the O.J. Simpson trial, basically. I think everyone had experience of watching that and seeing what a circus it became, and also seeing the extent to which media coverage seemed to contribute to the fact that it was a circus. But I knew that all the research showed that in most cases, those concerns were overblown, and that media could cover court proceedings, including having cameras in the courtroom, and that it wouldn't have a dramatic effect on the contour of the proceeding. And to my pleasant surprise, that has been my experience, and I think it's been the experience of most of my colleagues as well. The fact of the matter is the cameras are in there, and maybe if you walk into the courtroom at the beginning of the day on something that's going to be heavily covered, it's a little bit intimidating at first when you see all the cameras there, but the things that we're dealing with are so complicated that once you get started and you're focused on what you need to pay attention to, you don't have room in your mind to worry about the media anymore, and it does kind of go away. And I think that's true for the lawyers too. I don't think that attorneys behave differently or witnesses behave differently in the courtroom when the cameras are there versus when they aren't. It is true that we are limited in what we can say about matters that are pending before us, and there are good reasons for that. We're not supposed to talk about things that are under consideration generally, as Judge Pullman pointed out. And talking to the media, I think would particularly undermine the public's confidence in the judicial process. If you had judges that were in the middle of a decision-making exercise or presiding over something where a jury was going to be making a decision, who was commenting on what was going on and answering questions to the media, that could easily undermine the public's confidence in the integrity of the judiciary. I think it's important also when you're a judge and you're presiding over things that are being covered by the media, not to follow too carefully what's going on in the media. I think it's a good idea to have a rough idea about sort of what the press coverage is so that you can be sensitive to things that might affect your jury, and you can take extra steps to try to warn the jury about what they need to avoid and things like that in terms of coverage. But if you allow yourself to be swayed by the tenor of media coverage, then it makes it harder to do your job right. And so I think part of the ethics of being a judge is to avoid sort of following the blow-by-blow media coverage of the cases that are pending before you. We are lucky in the 3rd District Court, or in Utah generally, to have Jeff. And those of you who are media members, raise your hand if you know Jeff the Talk. Anybody not know Jeff? So raise your hand, Jeff. Jeff is an employee of the administrative office of the courts, and he's a media liaison. And so a lot of things that you might have questions about as reporters where you'd like to ask the judge, but you can't for these ethical reasons that I pointed out, you can ask Jeff, and he can answer some things that the judges can't. General questions about how the process works and things like that. One thing that I have noticed is that often, and I think that Utah journalists are pretty good about avoiding this, but often there's coverage of matters that are pending in the court that is inaccurate, misleading in various ways. And so I would just encourage members of the press, when you're covering the courts, to make sure that you understand exactly what's going on and report it accurately, because if you get something a little bit off, it can create public outcry in a way that's perhaps not warranted. A couple of examples that I can think of are, I remember reading a case, this was not one of my cases, but it was a story about a case that involved a circumstance where a trial court judge had determined that the defendant in the case was not competent to stand trial. And that's under a statute where you determine whether or not the defendant has the intellectual capacity, mental capacity to participate in the trial, stand trial. Sometimes if they're not competent to stand trial, they can get restored to competency later on. Sometimes they can't, but the case is not adjudicated. They're not let off the hook. They're usually still incarcerated while competency restoration efforts take place. And this case was reported as though the defendant was exonerated, as though it was not guilty by reason of insanity. And that was just wrong. That wasn't what had happened, and it created a lot of hue and cry and outcry in the comments. And it was because of a small error in reporting that impacted the public's perception of what had happened. And so you bear a large responsibility in how the public responds to things that happen in court, depending on how you report things. Another thing relates to, most of you probably know about how we have indeterminate sentencing in Utah. And it's different than in other states. So for example, if someone's guilty of a second-degree felony and they get sentenced to prison, they get sentenced to an indeterminate term of 1 to 15 years in prison. And I'll admit that before I was a judge, I was a civil lawyer. I didn't know that. I thought that, well, 1 to 15 is the range, but when I'm a judge, I'll pick something. I'll say, okay, 7 years. But that's not what happens. You actually impose the sentence of 1 to 15 years, and then the Board of Pardons and Parole decides how long the person is going to serve. But those often get reported as though someone got sent to prison for a year. Even though it's 1 to 15, they're likely to serve longer. And sometimes those stories get perceived by the public as this person getting punishment that's too lenient. And so these little things about being precise and correct about the legal standards that are applied and what really happens in court can make a big difference. And Jeff can be helpful with that. So I would just encourage all of you when you're covering these matters in court to try to get that right to the extent that you can, because we can't come out and say that's wrong. You won't see judges coming out trying to correct these things on the record. We can't, and we shouldn't. But you have a lot of power in terms of the way that you report these things.
I'm kind of on the flip side of Judge Nolan and Judge Blanche in that in my justice court, I probably have the least amount of experience dealing with the media. For the main reason being because the cases that we handle in justice court are relatively benign. We're dealing with class B and C misdemeanors. They're not the sorts of cases that garner a lot of media attention. Judge Blanche and I were actually talking earlier today that the most likely scenario where I'm going to see the media interest in my courtroom is if there's somebody who's locally famous who picks up a DUI and they want to come in and see what's going on. So since I've been on the bench for just about 2.5 years now, I've only had media interest in one of my cases, and it was regarding an individual who had made threats to essentially shoot up a school in the area, and he was charged with a misdemeanor offense for that. So when I do get those scenarios that arise, I have Jeff on speed dial on my phone, and I call him to see what we need to do, and he's very helpful in letting us know what actions we need to take and what precautions we need to take, and what we're bound to do under the rules. But we do have that ethical code, or the code of judicial conduct, that prevents us as judges from making comments on pending matters. And we also, under that rule, and what I need to do in my court, because we do have so little experience with these things, is make sure that my staff is trained on that as well, because that's part of our duty as well under that rule, is to make sure that our staff isn't making comments that they shouldn't be making. And in a lot of justice courts, I have 6 full-time clerks that work for me, and a court administrator, and lots of courts have even more than that. So we have a lot of clerks that we have to make sure are all on the same page and aren't making improper comments if they should get a phone call from the press or something like that. So that's my main concern in my court system, and I think probably that would speak for most of the justice court judges in the state. It's just that we not only follow these rules ourselves, but train our staff to follow them as well.
The That's very helpful. I think you each have sort of touched on your perspectives on the relationship between the judiciary and the media in your courtrooms. The press is, of course, identified specifically in the First Amendment, but under the First Amendment, there's not a whole lot of difference between the press and ordinary citizens. So just to sort of button up this issue, I'm curious if any of you feel like, well, your perspectives on ways in which media and ordinary citizens are alike in your courtrooms and ways in which they may differ.
Well, anybody can come into the courtroom, it's public, so the press can come in the way that anybody else could, and that's how they cover things in federal court, is that they come in just like a member of the public would with a notepad and take notes and make sketches and things like that. And so I assume that it's consistent with the First Amendment to exclude cameras and recording devices and things like that from courtrooms, because the United States Supreme Court does it. So. And so I think that to the extent that different court systems are willing to accommodate coverage that involves photographs, video, recordings, that they're going above and beyond what the First Amendment requires. But we've made a policy decision in Utah, which I think has worked out well, at least in my experience, I can only speak for myself, to allow greater coverage. And so things that the media is able to do things in courtrooms in Utah that ordinary citizens can't. So the rules that allow video coverage, the rules that allow recording of proceedings, those things apply to news organizations, not to general members of the public. And we sometimes get into issues about whether or not someone is a news reporter for purposes of the application of these rules. That does come up. And we have rules in place that sort of streamline the way that it all gets handled. As many of you know, there is a pool videographer, there's going to be a pool photographer, pool audio feed, so that you only have one person in there. You don't have 18 cameras in the courtroom. There will be one person that is going to take the video, and then that person, because they have the privilege of being the pool videographer, has to share the video with all the other news organizations that want to cover the trial. They can't just keep it to themselves. That's sort of quid pro quo if they're the person who is the pool videographer, and the same is true with these other media. There are some responsibilities that come along with that. So if you get designated as the pool videographer, it's going to be your responsibility to make sure that you're familiar with and follow any restrictions that are put in place. The biggest one that judges worry about the most is photographing a jury. I don't know a judge who would be comfortable with photographing a jury. And I really appreciated a trial that I had where the videographers that were covering it, they set up some fairly sophisticated cameras that were little cameras that kind of swiveled. And they went out of their way to make sure I had a chance to look at and approve the whole media setup in the courtroom before the trial started. And one of the things that they went out of the way to show me is that this thing that swivels, we've got it positioned in such a way that even if somebody makes a mistake and swivels it as far as it physically can go, it won't turn far enough to pick up the jury. Because they knew that that was important to me and that that was something that they had to be careful about. And there have been circumstances with news organizations that have been less careful about things like that, where you've had victims photographed who there have been an order in place that they can't be photographed. Jurors have been photographed where there was an order in place that they couldn't be photographed. So I think we are all eager as judges to be cooperative with journalists, but we expect corresponding care on the part of journalists about these kinds of limitations, and also not giving us pushback and difficulty about the pool feed arrangements. We've gotten some of that with national news organizations where somebody comes in and says, well, we want to be the pool coverage person, but we don't want to share this with anyone else. This is our stuff. These are our expensive high-definition cameras, and we don't want to give this feed to anyone else. Well, the answer to that is going to be, well, then you're not going to be the pool person. If you want to be the pool person, you have to share it with other people. Another thing that we've run into from time to time is that there's someone who comes in and they get their foot in the door first, and they want to be the pool coverage outlet for a couple of days of the trial. They think, well, we don't want to cover it wall to wall, but we want to cover the opening arguments or the opening statements. We want to cover the closing arguments. We want to cover the verdict when the verdict comes in. We want to cover a particular witness who's going to testify. So they don't want to be there every day. And if you don't want to be there wall to wall, you just need to be explicitly clear with Jeff about what you're going to cover so that he can convey to the other news outlets. If you want to have video, audio, and other things with respect to the things that the pool outfit is not gonna cover, you need to step forward and put in a pool request to cover the other things. And there needs to be good communication about things like that. Otherwise, the journalists are treating each other unfairly, and it puts us in a difficult situation.
I have something to say about that. Anyway, as far as juvenile court, I guess my other 30 fellow juvenile court judges on the state bench will probably hate me, but I would like to have more coverage of what goes on in juvenile court. There's still this myth out there, people come in all the time and my door's unlocked. I mean, you can walk in my courtroom, anybody can walk in my courtroom anytime. Juvenile court is not closed. There's certain instances where it is, but in general, I have to find an exception to the rule in order to have somebody dismissed from the courtroom. And so I would like to have a deeper coverage as far as these juvenile court cases. Because I think sometimes I'll hear the case on TV or I'll read it in the media, and I'm like, that is close, but it's not quite right. I mean, I'm like, I know the person who wrote this article did not quite get the process all the way. And they're close, but they're still, because I think the media is so important. Not to get all 8th grade civics lesson here, but the only power the courts have as the third branch of government is the public's confidence in the functioning of the courts. I've never appropriated any money. I don't take any tax money in. Can't do that. I can't change the law. I have to enforce the law. We're not the executive branch. So really, it's the public's confidence in our judgment of following the laws and giving people a fair day in court. That's where the power of the judiciary really derives from. And so I really would like the media to knock on the door or come into juvenile court and sit there through a child welfare case and see what really happens with DCFS and the guardian ad litems and the defense attorneys. Or come for a delinquency. If the juvenile's over 14 years of age, you can walk in the door. That's the deal. And like I said, I can exclude people. I have excluded some people sometimes, given the sensitive nature of the case, but I take it case by case. So I just think sometimes the coverage needs to be a little deeper when it comes to juvenile court. Everybody still has this myth that it's a closed case, and that's not. They are not closed courtrooms, and they've been open for quite a while now.
Can we follow up on that?
Yeah.
But the problem is that we can't get the information about that hearing that we want to be at because we don't have the name, we don't have the case number, and we can't get that information.
And you know what, I think that's a really good point. No,
We've tried. We have a couple of great juvenile court cases, as you may be aware, in
Right.
Summit County.
And you know what, I have been on the subcommittee for media bench relations since the inception, since day one. And I know that's been a subject we've talked about in that committee, is how do we let the press know, hey, you've heard about this case, you know, from the police or whoever, you've got information that this case, how do we let the press know when that individual is going to be in court? And so your point is well taken, absolutely. And I know, Jeff, we're working on that, on the bench committee, right? That very issue, because I know all of a sudden they'll pop up a hearing and the media doesn't know about, oh, that case is being heard today at 8:30 this morning. Go ahead.
Just to clarify, I did get an opinion from Administrative Office of the Court's Legal Counsel about particularly hearings involving high-profile juvenile cases. So most of you are familiar with the rule that governs access to the juvenile court documents. They're a lot more restrictive than actually attending the court proceedings themselves. I was told that if you have a reasonable description of the events that took place that are related to the case, you don't necessarily need to know the juvenile's name or age. Then I can release the upcoming court hearing dates for that. Now we don't post juvenile hearings on the calendar. We don't have a public juvenile court calendar, and that's way above my pay grade. But in terms of if you say, hey, if you're looking like when is the kid that released bear spray in the school, when is his next hearing coming up? Then I can check with our juvenile court executive and get that information from you. It's kind of a clunky system, I know that, but in terms of accessing the actual documents like the petitions, the criminal juvenile case history, and disposition, under rule, those are public record if they're over the age of 14 and charged with a felony level offense. Those are public record, but we have to go through a process of screening and releasing that information. So it's certainly not as smooth as what has been built out in the district court, but we do our best. But just so you know, In order for bottom line, in order for documents to be released, you need the name and age of the juvenile in question. If you just want to know when the next court hearing is in that situation, just give me a reasonable explanation or description, and then I can let you know when the next hearing is, as long as they've been charged. Hope that makes sense.
Follow up on that too.
Yes, please.
I just want to follow up on something that Judge Blanche was talking about, and that, I mean, obviously I'm not, again, dealing with these big media cases where I have the pool coming in and whatnot, but we do have in the justice courts, we have had a recent issue with people who have come in claiming to be, whether they're claiming to be sovereign citizens or members of the media because they have a blog or whatever the case may be, coming in and just throwing up their cell phones and starting to record the proceedings, recording the judge, recording defendants, recording victims, recording everything. And they're asked to be removed from the courtroom and they cause a huge stink. There's a big uproar, you know, yelling, screaming, whatnot. So in response to that, a lot of justice courts have issued decorum orders. So I have a standing order in my court now that explains when someone can use electronic media, and it essentially says when that person is a member of the media and it's approved by the state. So other than that, in any common areas, in the courtrooms, any area inside of our building that constitutes part of the court, no one's allowed to have recording devices, whether it be audio, video, whatever the case may be, because we can't determine whether somebody is a member of the media or they're just claiming to be, and they haven't gone through the proper channels. So we have these kind of standing orders that are posted in the court to let people know that that is not okay, and we've discussed how to handle it if someone comes in and does try to do it on their own. I also just wanted to mention, I don't mean this to be a plug for the bar necessarily, but in the Bar Journal last issue, Judge Farr, who is in Sandy Justice Court in Harriman and Alta, I believe, wrote an article, he wrote a piece on the importance of both the freedom of the press and the independent judiciary, and how those are two things that are necessary for a democracy to operate, and the importance of those two groups working together to ensure that we give that to each other. And it's kind of an interesting piece. I just read it this morning, actually, so you might want to take a look at that, because I think it really kind of gets to the heart of what we're talking about today.
I thought I would just talk briefly about access to the Court of Appeals and to the Supreme Court, for those who may not be familiar. So our calendars are posted online, are easy to access, so you can see what arguments are going to be coming up, and usually about 2 months out. They might be slightly earlier than that, sometimes maybe slightly later, but usually about 2 months you can see what's going to be argued in either court at what time. We also are subject to the same pool request requirements, so if people do want to come in, take video or record, they can make those requests, and those are, at least I've never seen one not approved. So, and they're pretty rare. I'm not sure that appellate court makes for the best TV, but occasionally people do request those. The one great thing about our courts is that we live stream every argument. So if there's something you may not want to go to court for, but you're interested in, you can get on the website and listen to the argument as it's taking place. And then we also leave those recordings up on the website, so if you miss something, you can go in later that day or 2 weeks later, whatever it is, and you can hear the arguments. Sometimes it's nice to be in the courtroom. If you're interested in recording specifics about which judges are asking which questions, those kind of things, sometimes it's nice to be able to see that. It may be unclear from that recording. We usually do ask the lawyers to make their appearances, but the judges don't announce who's asking the question every time something comes out. But at least gives you access, quick access, immediate access, and continued access in the event you want to hear those arguments. The Court of Appeals has also been investigating the possibility of getting video in our courtroom at all times and just always having a video feed. And so we've been looking into what other courts do, kind of evaluating expense, those kind of things. So it's not happening right now, but it is something we foresee doing in the near future.
Those are really valuable perspectives, thank you. So let's switch gears a little bit to judicial decision-making that I think will be very interesting to, especially to the members of the media here, but also I get to ask the questions. So I'm very excited about it. Let's start with, and maybe we could start on one side or the other and just move down the panel. How do you understand the law, capital T, capital L, as it's interpreted and applied? I had a professor who talked about 6 modalities of legal reasoning: textual, historical, doctrinal, so on and so forth.
I do all those.
And so can you?
I'm glad I'm in the middle right now.
Can you help us understand your process as you approach making a decision?
about my job is that as a member of an appellate court, my job is not just to look at a case again and see if I see it differently, right? I have standards of review that I have to apply and that govern the decisions that I can make. And so there's some things that are appealed that the district courts have a wide amount of discretion on. Sentencing is maybe a good example of that. And so unless I determine that the judge has acted outside the bounds of reasonableness, then that decision will be affirmed, even if I personally might say, well, if I was that district court judge sitting on that bench, maybe I would have done this differently. I never really want to say that because I realize that I'm not there in that courtroom. I'm not hearing things firsthand. I don't have all of the information necessarily. At least I'm not seeing people's kind of demeanors, and I can't judge credibility. So I would never be so presumptuous as to say I could make a different decision. But even if I thought I could, if it's within that bound of reasonableness, is something you felt would affirm. And you know, you see oftentimes defendants or parties who think, I just need to talk to someone else. I just need to have someone else hear these facts in this case and I'll get a different decision. And that's not how the appellate court works. We look for error and we look for abuse of that discretion. There are some issues, of course, though, that we just decide that are just purely legal issues. And so we decide them really in the first instance again, right? Someone will explain to the district court they think has made an error in applying the law, and we will look and see whether or not we agree with it or disagree. And so each of my decision making, you know, whether I'm looking at a statute or a contract, I'm going to do very specific things. I'm going to look at that plain language of those documents or those statutes and try to interpret what those are. If I'm looking at whether there's sufficient evidence in a trial, I'm going to look at the entire record and see what happened below and see if the decisions that came out, I think, are warranted by that record. So it's a hard question to answer just because there's multiple different scenarios and different kind of cases that we decide. But I think the most important thing when you're reporting on an appellate case is to realize that it's not just a do-over. It never is. It's always a question of whether there were mistakes made. And then sometimes even if mistakes were made, whether those mistakes are significant enough that it warrants a new trial or a different decision below. And so we are very constrained in our application of the law, and we're bound by those standards of review.
Yeah, this question kind of reminds me of a question that I was asked by the governor when I was going through the selection process. And I think most of us who were appointed, at least by Governor Herbert, were asked this question about what it means to be a judicial activist. And there's a temptation to give sort of a snide answer to that question and say, well, a judicial activist is a judge who makes a decision you disagree with. But it turns out that whoever bothers to ask you that question doesn't think an answer like that is funny. Because I think that they're getting at something that really is an important concept, and I think that they are. And so I, in answering that question, said, well, here's what I think a judicial activist is. I think it's somebody who doesn't feel constrained by legal standards, statutes, principles, decisions of higher courts, and just does what he or she wants. And I would never be a judge like that. If I wanted to make policy, I could become a legislator, I could run for governor, things like that. But if I'm a judge, my decision-making process starts with, what is the standard that governs the decision that I'm going to make today? Is it a statute? Is it a common law line of cases from the appellate courts? Is it a regulation, an administrative regulation? So I have to find that first, then I have to read it and see what it says, and sometimes it's crystal clear it's what it says. Sometimes it isn't. Sometimes it's a little unclear. It can be read in different ways, and then you look to see whether the Court of Appeals in Utah or the Utah Supreme Court has interpreted the statute, the regulation, whatever it is that guides my decision making. If they have, that answers the question. I'm bound to follow those appellate courts. If they haven't, is there a similar statute or regulation in a different state that's been interpreted by that state's courts? And those are not necessarily binding on me, but they can be persuasive. There are just these layers of analysis that you go through before you get to the point where you say, well, here's what I think the law should be, here's what I think the standard ought to be that I apply. Sometimes you learn that the decision that you're making is not something where there's a black and white answer that's crystal clear, but it's an area that's committed to your discretion, and you can decide one way or the other, and then it's incumbent on you to make sure you get all the information that you think you need to make the decision in a fair way. And get the information using a process that makes the parties who are participating in the proceeding feel like you took them seriously and you listened to their arguments, even if you didn't agree with them. You heard everything that they had to say, and I try to make it a point to comment on arguments made by the losing party and why I wasn't persuaded by them, so that people at least know that I listened to them, Even though I didn't accept their arguments, I considered them and I understood what they said, I just didn't agree. I have hundreds and hundreds of cases, and they come at me very fast, and so some of these decisions I have to make in a hurry. I prefer to be able to sit down and think about things for a long time, but sometimes in a trial, for example, things just come at you quickly. It's very reassuring for me to know that even though I try to do my best, and I never use this as an excuse to do something in a deliberately slipshod way, but it's very reassuring for me to know that we have these other tribunals that can review whether there was a prejudicial error that occurred in something that I was involved in. Because certainly my pride associated with my decision-making is not nearly as important as the justice that occurs in the courtroom and that people are getting a fair outcome in these proceedings. And so that's my general approach to these kinds of things. Very important to be fair to both sides, very important not to have a dog in the fight on one side or the other if you're a neutral decision maker. All those things I think are important.
So in the justice courts, I agree with everything that Judge Pullman and Judge Blanche have said. I try to operate the same way. We have the most substantive hearings that we have in justice courts are domestic violence cases and DUIs. And those, as far as sentencing goes on those, it's pretty standard. We have things that are mandatory, we have things that are guidelines, and we do our best to follow, I do my best to follow those guidelines. The main difference, and I think that a complaint that we hear often from attorneys that practice in justice courts are not courts of record. So we can finish our case in justice court, and no matter what the outcome is, it can be appealed to district court and it just starts over. They don't review my decision. The judges at district court don't review my decisions for their correctness. It just starts over. They don't care what I did or what I said or how I ruled. The case just starts from scratch at district court. So a complaint that justice court, that attorneys that practice in justice courts have is that the judges don't take the time to make the decisions that they should because they know that it's just going to get appealed to district court and what they say or do doesn't matter at the justice court level, which is not the way that we should be operating, obviously. That attitude, and I'm not saying that that is a regular attitude amongst justice court judges, I don't think it is, but the danger of that happening is huge. The effects that has on the individuals that appear before us is huge. It's more time, it's more money, it's more resources from the courts and from the state to take that tact when you're working as a justice court judge. So I try to be very, very careful about the decisions that I make. If I have a motion to suppress in front of me and I don't know the answer to the question, I take the time to do the research and figure out what the answer is rather than just ruling and getting everyone out of my courtroom. I think that we need to afford every individual that comes before us the same attention and the same time and the same commitment to following the law as do district court judges and appellate court judges and juvenile court judges and Supreme Court justices. So it's a kind of a different situation at the justice court level because we have to remind ourselves that even though it might just end up starting over again, what we're doing down here matters. So that's kind of how I try to operate.
Juvenile court, it's an interesting place. I'm glad I'm on the juvenile bench. Best interest of the child, what does that mean? We have some parameters on what we can do, but a lot of it just comes down to judicial discretion. And so what I try to do every day is I try to be really prepared. So I want to be the smartest person in the room on this case as possible, and that's hard. So it means I usually, my Tuesday nights before my child welfare day, which is Wednesdays, I spend the evening going through every case and going back over the minutes for the last 2 hearings and those type of things. So preparation's one. The other thing is I try to check my bias at the door. So that if a parent's emotional and they're upset, or defense counsel or the AG or whoever's upset about something, I don't let their upset determine what's right for the case. And that's hard to do. I'm sure I'm not perfect at it, but I really try to check the bias at the door. Another thing, I try to be just a really blank canvas when I walk in and listen to all the parties and realize this is an emotional time. One thing we struggle with, and I appreciate attorneys in the room who are patient with us, is when we do get behind sometimes. And I really am a stickler about showing up on time and holding court on time and keeping on track. Yesterday, for example, it was a tough morning. And so I have a 13-year-old sitting there, and I'm 40 minutes behind on my calendar, and I'm counting the clock's right behind the parties. I can see the clock, it's right there on the wall. So I got a 13-year-old whose dad is facing serious aggravated assault kind of charges because he tried to kill mom. Dad tried to kill mom, gunfire went off, big car chase, I won't get into all the details. So I have a 13-year-old that doesn't want to go to school and wants to become a YouTube influencer, whatever the heck that is. And so I can tell this 13-year-old thinks that that's not the way to go, and school's no longer important, 8th grade, it's not that cool anymore, because they're gonna be a YouTube influencer. And I guess their parents can pay their way into college, but that's a whole different other story. But anyway, so I have this 13-year-old who's really having emotional problems, and there's 4 kids here. And so my question is, do I push this along, or do I kind of hear him out for a second and kind of have a conversation from the bench with this kid? And so you can see as a judge, you're thinking, oh, I'm 40 minutes behind. I still got 7 cases before we break for lunch here. And what do you do? And so as a juvenile court judge, it's kind of hard sometimes, because you have to think, okay, I'm going to take a minute here and just take a breath. And it's like, you know what? The other case, you're going to have to wait. And so that's just an example of kind of the dynamics of what we deal with. You're also, we all make serious decisions. And yeah, there's some serious stuff you got to really consider. Terminating somebody's parental rights. You just sent that kid off on a total different trajectory in their life. You know what I mean? They're being adopted by strangers, essentially, and their whole extended family from their parents is gone. And so it's, I mean, or if you send a kid to adult court, decide to certify him to adult court, you just sent that 15-year-old on a whole different journey. And so, you know, it's just an interesting place. We have a lot of discretion. I appreciate the Court of Appeals always letting us, you know, they give us a wide berth on that best interest. And so, and the governor, he talked about judicial activism, probably back to 2010, Governor Herbert. Federalist Paper 78, talking about judicial activism. And I'm with you, Judge Blanche, and the other judges. I'm not an activist. I just try to use the best discretion when it comes to making the call and do your best and move forward. So that's how I do it.
As tempted as I am to chase that YouTube influencer concept down, and we're running short on time, so I do want to underscore something before we move on from judicial decision making, and that's a theme that I think has been constant in each of the responses, and that's the importance of procedural posture. And going back to what Judge Blanche said in his opening remarks, when I represent a lot of reporters. I love our media clients, and I'll defend you to the death. But every once in a while, there'll be an article that will, I can see that there's an error in understanding the procedural posture that's infected the rest of the story. And I'll try to call them up and say, hey, you know, this is actually what the motion was, and walk through that. But it's so important. I don't know if the panel wants to jump in here, but before we move on, but if you have any questions about what does this decision mean, what is this brief that I'm looking at, you know, how a motion to dismiss differs from, you know, a jury verdict. Those seem obvious, but as you get more and more nuanced, they can get complicated. So make sure that you're double and triple checking those procedural postures. Yes, please.
When I was an associate at Stolreeks, I worked on a case for about 7 years involving the Salt Lake Tribune and the Deseret News and fights over ownership and management of the paper. And it was a fascinating experience for me because there was a lot of media coverage. I mean, these two papers were in battle with each other, and so there were always reporters there reporting on all the events in the case. And it was very eye-opening to me to just see, as a lawyer, sometimes what makes perfect sense to me or what I understand because I've been living with it for so long in my practice is not necessarily obvious to someone who is either not law trained or just not living with lingo and these kind of situations on a day-to-day basis. And so I would just encourage you to never worry that you're asking a dumb question. I think as lawyers, sometimes we might speak in a certain language and we just forget that we've been living in that realm for so long, that the things that we're talking about, especially when you're talking about the posture of a case or what a particular motion might mean or what a particular result might mean, it's easy for us to forget that those nuances are not obvious to everyone. And it is in our interest, both as lawyers or judges, to make sure that those things are reported accurately. So I would encourage you, just if you've got a lawyer friend on speed dial, call them up and just ask them, that question, or ask the lawyers that are involved in the case, or ask Jeff. But I would never worry about asking a dumb question, because honestly, it may be something that's obvious to us, but we forget that it's not obvious to those who don't live with it all the time.
And I'll also drop it to the Freedom of Information hotline. You're always welcome to call us and ask us what something means. those are the best parts of my day. When reporters call up and there's some exciting thing that's coming on, coming through the courts, and they've got the scoop and they're trying to understand what something means. That makes my job a lot of fun. So please call the hotline, use it. That's what it's there for. So, in our last few minutes, let's shift now to the relationship between the bench and the media. And we've also talked about a little bit. We've touched on the media's coverage of the judiciary. So let's just kind of combine those last two categories. Utah is one of the very few states that has this sort of special forum in which we can vet issues and have discussions between the media and the judiciary, and that's the Bench Media Subcommittee. And there are some members of that subcommittee in the room today. Judge Pullman and Judge Noland. Judge Pullman is the co-chair of that committee with me, and as Judge Noland said earlier, he was around since the inception of that subcommittee. And if you could just give us your perspective on how that maybe a brief history of that subcommittee, what it was intended to do, and some of the work that it's done.
Well, I've been on the subcommittee for, I think, just a little over a year. It was created in 2013, but I actually find it really interesting. I think it's great to be able to interact between the bench and the media because, again, sometimes there would, I think without this, there wouldn't really be a forum to have these conversations and to address these issues that either concern the judiciary or that concern the media and find a way that we can work best together and make sure that we do things efficiently and effectively. I would maybe ask Judge Nolan to maybe talk about, since he's been on it since the inception, and what you've seen as far as its purpose originally and what it's been able to accomplish.
It's been really good getting back to what Judge Blanche said, the old OJ thing, which really just kind of just took the trial off a different direction with the media coverage. The committee was formed, I guess it's been 6 years, I can't remember how fast time flies, but it was formed to really get a working relationship where the media would sit down with members of the bench and really talk about how things occur to the media. Like, this is how it is in real life. You're saying it's open access or this kind of thing, like the juvenile court kind of thing, where it's really such a good open forum where the media can really express their concerns or say, hey, this isn't workable. This just doesn't work. And also, I think what it did is it really brought some decorum to the coverage of cases, high-profile cases, which are media-worthy in the courts. So you don't have 3 or 4 or 5 different cameras there, which really distract away from the justice part of the order of the court. Because I can't imagine being a witness or even being a judge if there's all this media going on, you know what I mean? And hear witnesses trying to just testify about probably one of the worst things that ever happened to them in their entire life. And so I think it's really gotten down into the weeds as far as the details on how the media should cover, who's doing it, how it's disseminated to the other media members, like really the step by step. I got to give one shout out or one commendation to our media. I really appreciate the fact that in juvenile cases and those kind of things that involve juvenile defendants or juvenile witnesses or those kind of things, you always keep their identity anonymous. I really thought about that in preparation for this. Like, I don't know if you really have to or not. Is there a rule or is there some? And I don't think there is. I think it's just good media practice. So I wanted to make sure that point came across. I just appreciate the fact that even with juveniles who've been charged with real serious things, you have respect for the system, and I really appreciate that. I wanted to come across. So I like the bench committee, the subcommittee, and it's great. If there's any issues, they can be brought out and talked about in a really good forum. And so I really want to know how it's going, like how's the bench doing and how's the media doing as far as that relationship.
If I could make a quick point, just relating to what Judge Nolan said about appreciating the media, keeping anonymity with respect to these juvenile defendants. I've noticed sometimes, I don't know if this is deliberate on the part of the media, but I've seen some coverage of cases where it's a jury trial, it's going on for a period of days or weeks, and there's an argument that takes place outside the presence of the jury about perhaps very incendiary evidence that perhaps should not come in. And there's a discussion on the public record about what that evidence is, whether it should be admitted, and I might rule or another judge might rule, no, that's very prejudicial, damaging evidence. It's not sufficiently relevant to be admitted, it's excluded. And I find that often responsible journalists don't go into a whole lot of blow-by-blow detail about what was excluded. And I think, I'm glad that the story was written that way, because if one of these jurors happens to see the story, well, that juror would probably have to be excused anyway, there would at least be a chance that they didn't get tainted by what I decided they couldn't see because it got reported in a news story that they happened to stumble across. And so I have sometimes sensed that journalists who were writing about those kinds of proceedings were sensitive to those kinds of concerns, and were taking them into consideration in deciding what to write and what not to write in their stories. And so that's something that I've appreciated on the part of the media.
We've got just a few minutes for some questions while you're thinking of any questions you'd like to ask. Okay, so you'll go first. I just want to also highlight the importance of the journalistic standards and ethics and the exercise of editorial discretion. Because when we show up as advocates on behalf of the media, we need to have credibility. When we make this argument all the time, we say, whether that name is released or not is not a matter for the court, it's a matter for editorial discretion. We need the judiciary to trust that when we represent that our media clients appreciate that maybe a 14-year-old's name should be in the media for some story, that we mean it, and our clients are going to follow that. So, you had a question?
Yes. Interested in the judge's view of their position and responsibilities when they're trying to apply the laws day in and day out, and they're going through the interpretive understanding of those laws. If they see a statute or a policy that does not make sense, is difficult to apply from the court standpoint, how do they communicate that to the legislature? I don't know what the relationship between the courts and the legislature with the media in there too. I think it's important for the courts to be able to say, this is a bad law. This needs change, legislature, but I don't see how they get to there without having good media available to address those problems. How do you address that issue?
So we have legislative liaisons that are judges I think at each branch. I know there's at least one in the justice courts and the district court. I'm assuming there's one in the juvenile court, and at the appellate court levels as well. But that their job is to do just that. So if there's a law that is, and it depends on whether it affects our operations. If there's something about a law that's being written or a law that's in place that is making it difficult to practice or is affecting our day-to-day operations, then the legislative liaison will approach legislators and go to meetings and have discussions about that to maybe not try to change the law, but to let them know of our concerns. To let them know if it's going to have an impact on the way that the courts are run, on the way that that those cases will be handled going forward. But there are constraints on that. If it's a law that just, that's going to change the class of something, if it's going to change domestic violence from a Class B misdemeanor to a Class A misdemeanor, and it's not going to have any effect on us whatsoever, which is not the case because that obviously would. But if it's not going to have any effect on the courts, and it's just something that the legislature is going to change, then they don't necessarily say anything about that, even if the judges as a whole don't agree with it or don't want that to happen. But I think it comes down to whether it's going to affect our operations, and then they have those conversations.
I also think, the appellate courts probably have the most opportunity to at least signal something if we see that there might be an issue. We do that through our opinions, largely. It's not something that happens very often. We're very careful and cautious and respectful of the division of the different branches of government and what our proper role is. But occasionally, if we see something in a statute that's just really hard to decipher, or we perceive it as unworkable, or we even perceive that perhaps the legislature might have meant something else, but they created something that says otherwise. You might see us dropping footnotes or having a separate opinion written in those opinions, which will say our legislature might want to consider this. I don't see that very often, but it does happen from time to time if we feel like it's something that we want to make sure that is brought to the legislature's attention. But we don't see it as our primary role to tell them how to do their jobs, obviously. So it's only in kind of the rare situation, but you will see that occasionally in opinions, and we often wonder if those are seen and read, and I think in many cases they may be, but it's kind of the best way we have to alert them to that.
I was going to say, along those lines, Judge Fuller, that's that's where the media can be helpful. Because if the media's gonna report on the courts, what would be really helpful is, if a judge makes a decision, you may not, the public may say, oh, why is the judge deciding it that way? I like to see the media say, here's what the law says, and the judge just applied the law. But it wasn't the judge that was exercising a bad call or bad judgment here, but the judge actually exercised the law. And so all of a sudden, if enough people say, wow, I don't like that outcome from that law, then that can motivate the legislature to do something. So I really like when the media really differentiates. There's the judge exercising their discretion, and then there's the judge following the law. You know, this is what the law says, I gotta follow it. And the public or the media may go, well, that's a bad decision. Well, no, you're fulfilling your duties as a judge to follow the law. Facts in the law equals decisions. So I appreciate when the media will really parse that out or make that clear that, you know what, the judge followed the law, and that's the law. And so if someone wants to change it, there's a state capitol right here, you can go do it.
We don't have the prerogative to decline to apply what we believe are unwise policies that are otherwise constitutional. That would be judicial activism in its purest form. And so I think, Oliver Wendell Holmes said a salty thing. I think I'm going to get this wrong, but he said something like, if people want to go to hell through their elected representative, it's my job to help them get there. And so, there are things where if a statute is unclear, if it's ambiguous and it can be read in a sensible way versus a ridiculous way, there are rules of statutory interpretation that you can use to decide it in a sensible way. But you always need to be mindful of the fact that you can't do that in a way where you're substituting your policy judgment about some issue for that of the legislature. And so I think we're all very careful about that. And so, there are 28, 30 judges on, I think it's going to be 30, 31 judges on my court. And I don't know the politics of the judges on my court. But I think that any issue that you can imagine the judges would have to decide, if we had a bench meeting and talked about how we would decide it, I think we'd all pretty much decide it the same way, because we all think about legal issues and address legal issues the same way. And that's what you want out of the judiciary, because it's a different job than making policy. So there is a role that the administrative office of the courts plays. The judicial council conveys views about different legislative issues every year to the legislature. And particularly those are things that affect the administration of the courts. But one of the guiding principles of the legislative liaison that goes and deals with legislators up at the Capitol building every year is that we don't weigh in on policy issues. Sometimes we'll tell them, this is your call, this is policy, here are some potential ramifications of this policy that you may not have thought through, so you at least have that in your mind if you decide whether you want to adopt the policy, but this is a policy question for you to decide.
And with that, we are out of time. Would you all please help me thank the Society of Professional Journalists, the Utah Bar Association, and of course our incredible panelists for their valuable time and insights.